team and at least some law enforcement personnel became aware of Mr. Grunander's child had attended the rally. No effort was made by the Utah County Attorney's Office to screen Mr. Grunander from the case or from speaking about his child's experience with other attorneys in the office. Mr. Gray consulted with his prosecution team, including Mr. Grunander, when determining which charges to file and whether to seek the death penalty. But the ultimate charging decision rested solely with Mr. Gray in his statutory capacity as elected county attorney. He made the decision to file a notice of intent to seek the death penalty at the inception of the case rather than waiting until after the arraignment, as allowed by statute. His decision to seek the death penalty was based upon his assessment that the death penalty is appropriate in this case. He chose not to wait to file the notice because he believed it would cause unnecessary speculation on the part of the public and angst on the part of the victim's family. Waters' presence at the rally did not materially influence Mr. Gray's decision-making, and the court finds that this conclusion is supported by credible testimony and objective record before it. Approximately 3,000 people attended the rally at Utah Valley University. Throughout the course of the investigation, over 40 attendees voluntarily provided witness statements to law enforcement, and several attendees provided video footage of the incident. No evidence was provided by daughter that she was not available from other sources. The state has chosen not to call her as a witness in support of its prosecution of Mr. Robinson. In October 2025, Mr. Grunander sent an email to defense counsel and disclosed his child had attended the rally at Utah Valley University, where Charlie Kirk was shot. Defendant moves for disqualification under Rule 1.7 of the Utah Rules of Professional Conduct, which provides in relevant part that a lawyer has a concurrent conflict of interest if there is a significant risk that the representation will be materially limited by a personal interest of the lawyer. In applying this standard, the court is mindful that this is a capital case. The decision whether to seek the death penalty is among the most solemn exercises of prosecutorial discretion, and allegations of bias or personal influence in that context warrants careful and searching judicial review to preserve both due process and public confidence in the integrity of these proceedings. Defendant argues that Mr. Grunander's relationship with daughter creates a significant risk that his decision-making will be and has been materially limited by personal interest, namely his loyalty to his daughter. Because no screening was in place to prevent Mr. Grunander's conflict from tainting the entire prosecution team, defendant argues that Utah County Attorney's Office should be disqualified from prosecuting this case. This is especially so because Mr. Grunander holds a supervisorial role in the office and is a key part of the prosecution team. Defendant has not identified binding authority establishing that a prosecutor has a concurrent conflict solely because the prosecutor has a familial relationship with the potential witness, particularly where the witness has no unique relevant information. In the cases defendant cites, the prosecutors were split between their loyalty to the government and their loyalty to the defendant, or a personal interest separate from the case being prosecuted. In State v. McClellan, the prosecutor had previously represented the defendant and had access to confidential protected information, which could undermine the defendant's right to due process. In State v. Balfour, the prosecutor had past financial, business, and political ties to a defendant, which could conflict with the prosecutor's duty to pursue justice and represent the government. In Wright v. United States, the prosecutor's wife was the defendant's political opponent whom she had accused of sending people to assault her. In State v. Tate, the prosecutor had been a judge on the defendant's case and had been privy to ex parte communications. In People v. Connors, the prosecutor was both a victim and a witness to a separate crime committed by the defendant, which created a personal grudge against the defendant himself. Each of these cases involve a personal interest directly connected to the defendant or some other interest that materially limited the prosecutor's representation of the state. By contrast, the record here contains no evidence that Mr. Grunander or any member of his family had a personal relationship with, bias toward, defendant, nor does the record show that Mr. Grunander's professional judgment has been or is substantially likely to be materially limited by his loyalty to his daughter. Speculation regarding potential influence is insufficient to establish a significant risk under Rule 1.7. The court has independently reviewed the evidentiary record with particular attention to whether any direct or indirect decision-making in this case reflects personal involvement inconsistent with the objective prosecutorial judgment. The court finds no such evidence. Defendant argues that two prosecutorial decisions could have been impacted by Mr. Grunander's relationship to daughter, thereby affecting defendant's due process rights. The decision not to call daughter as a witness and the decision to seek the death penalty. The court is persuaded by the evidence presented that daughter is not being called to testify because she has no uniquely relevant testimony to give, and the state has access to much stronger evidence from other witnesses. To the extent defendant believes his due process rights are violated by the state declining to call daughter as a witness, defendant has subpoena powers and a right to call her himself if he believes her testimony is important to his case. As to the decision to seek death, the court finds that daughter's presence at the rally did not factor into the prosecutorial analysis. The evidence supports that Mr. Gray's decision was grounded in his assessment of the facts and applicable law. Because the circumstances of every case are unique. Oh, I heard something. I'll continue. Let me start over on that sentence. Because the circumstances of every case are unique, prosecutorial discretion allows a prosecutor to consider a host of relevant factors when determining whether to seek death, as long as the considerations of those factors is constitutionally sound. Even if Mr. Gray considered the impact on daughter when deciding to seek death, defendant has not shown that the impact of the crime on victims, witnesses, or even prosecutors themselves is an unconstitutional consideration when deciding to seek the death penalty. In sum, the court concludes that there is not a significant risk that Mr. Grunander's loyalty to daughter has or will materially limit his representation of the state of Utah. Furthermore, defendant has not shown that there is a significant risk that Mr. Grunander's relationship with daughter has or will impact defendant's due process rights. Based on the record before the court, defendant has not shown that his prosecution by the Utah County Attorney's Office is tainted by a concurrent conflict of interest under Rule 1.7. During oral argument, defendant requested the court also consider whether the Utah County Attorney's Office followed the process recommended by the Utah Prosecutors' Best Practices created by the Statewide Association of Prosecutors, otherwise known as SWAP, in determining whether to disqualify the Utah County Attorney's Office. Defendant argues that best practice demands that a prosecutor avoid the appearance of bias based upon public perception. To avoid this appearance, the Utah County Attorney's Office should have immediately screened Mr. Grunander from the rest of the office. Because it failed to do so, there is now a hint that the decision to seek the death penalty was an emotional response to Mr. Grunander's concern for his daughter. The best practices document is not controlling on this court. And even if it was, the court is unpersuaded that Mr. Grunander's relationship with daughter creates an appearance of bias in this case. Prosecutors need not be immune to the emotional response of others to prosecute a case. Indeed, it is part of a prosecutor's duty to interview witnesses and victims and evaluate the impact of an alleged crime. A prosecutor need not be disinterested on the issue whether a prospective defendant has committed the crime with which he is charged. If honestly convinced of the defendant's guilt, the prosecutor is free, indeed obligated, to be deeply interested in urging that view by any fair means. True disinterest on the issue of such a defendant's guilt is the domain of the judge and the jury, not the prosecutor. And this is citing from Wright. Also, prosecutors need not be entirely neutral and detached. In an adversarial system, they are necessarily permitted to be zealous in their enforcement of the law. After reviewing the record, the court concludes that the familial relationship at issue, without additional evidence of personal involvement or influence, does not create a reasonable perception that the prosecutorial discretion was exercised for improper reasons. Zealous advocacy remains bound by constitutional and ethical constraints, and the court finds that those boundaries have not been crossed here. This ruling is confined to the specific facts established in this record. Different circumstances, such as evidence of direct personal involvement, uniquely material testimony, or demonstrable influence over discretionary decisions, could warrant a different result. In sum, the defendant has not shown that there is a significant risk that Mr. Grunander's loyalty to daughter has or will materially limit representation of the state, nor has defendant demonstrated that his due process rights are compromised by the continued prosecution of this case by the Utah County Attorney's Office. Applying this governing legal standard to the facts established in the record, defendant's motion is respectfully denied. All right, that order in a written form will be available shortly online. The court wishes to turn to its last matter, and the court wishes to address the remaining outstanding motions in a timely manner and to set appropriate dates for their hearing and resolution. The court recognizes that coordinating schedules can be challenging and that we all make a good faith effort to accommodate the court and one another in setting these matters for hearing so that the constitutional rights of all parties are protected and preserved. Counsel, I'm reviewing a list of motions before the court, and so I wish to quickly address that, set hearing dates so all parties have an expectation of what comes next and what to prepare for. And so I'll turn to the attorneys. The court has thoughts, but I want to hear your thoughts first.
Judge, this is Mr. Grunander. I apologize for my camera. Something's happening with it this morning, but
sure.
I see that the court entered a couple of rulings that we received late last night. I think there are still the outstanding motions to classify as private that need to be addressed. And then there is the outstanding motion from the defense to exclude media, electronic media coverage. And there is a request, and I'll defer to the defense, but there's a request for an evidentiary hearing there. But that's what I see as far as what's outstanding. In addition, Your Honor, I should say there is one with respect to a piece of evidence that we're trying to identify additional reports on to get to the defense so that we can be fully prepared to address that issue.
All right. Thank you, Mr. Grunander. Turning to defense.
Thank you, Your Honor. This is Richard Novak. I know that the court may have seen the emails which were exchanged with the court's clerk and counsel concerning scheduling. We had all suggested a date that the court was available to resolve the classification issues, some of which, as Mr. Grunander said, are still pending, notwithstanding yesterday's orders, and that was the date of April 17th. It was our expectation that the court would take care of the classification issues at a hearing that afternoon. The court's public order yesterday did address in a footnote a question of the media's standing with respect to, say, the merits of the motion that Mr. Garnander mentioned. So we think that that needs to be addressed because the media did file what they purport to be a preliminary response to a motion that is presently classified. So before we actually before the court conducts the hearing on the merits of the motion to exclude, which we anticipate would be an evidentiary hearing with both exhibits and witnesses, we think that it would be most efficient for the court to lay the groundwork on what will be public, what will not be public, and which entities, I'm not going to say parties because that's not right, which entities have standing to weigh in on that motion and the scope of that standing. And we do think, because I mean the court has obviously seen, because it approved the filing of the initial motion, that there's an extensive evidentiary presentation that's necessary. It's not going to be the 2 to 3 hours that we were told the court is available on April 17th. So our thought is that we would have all of that sort of preliminary and standing, all of the preliminary and standing issues resolved at the court's next availability that worked for council, which is April 17th, and that at some date after April 17th, we would then have the hearing on the merits of that motion.
All right. Any other?
Does that make sense, or did I just muddy it up even more?
No, I understand what you're saying. Any other input from any of the other parties before the court gives its input?
Judd. I think Mr. Novak mentioned the afternoon of April 17th. I think the court's availability may be that morning. And other than that, I think this plan sounds good and makes sense to the media. I think the remaining issues that are most likely to be argued and resolved at an April 17th hearing are individualized motions related to closure of things on the docket. In that way, there's kind of a commonality between those. There's likely some overlap, even though they're separate briefings, on the interests and the questions related to those motions to classify. I'll note that more may come along. There was a reply to the motion to exclude cameras from the courtroom that has also been subject to a motion to classify. But again, I think that could be argued easily alongside the pending motions to classify or close that the court is attempting to schedule for hearing now.
All right. All right, so here's the court's input. I wish to address the motions to classify and addressing the closure of the hearing for the evidentiary hearing to exclude media well before April. And I don't believe that those hearings will take a lot of time. And for this court, for many reasons, and because the court intends to keep the May preliminary hearing. And I realize that there may be things that come up that may affect that, but as we stand today, that preliminary hearing date is set. And I wish for these issues to be addressed prior to the preliminary hearing, given the nature of that hearing. And so there is clarity on what will happen. What dates do we have available in March? In council, before I get these dates, I recognize that you all have challenging schedules, but this case must have priority as this court is trying to balance the constitutional rights of all parties and being timely in its process. So I ask you respectfully to do your best to ensure that we can align to a schedule that allows us to move forward in a proper manner while respecting the constitutional rights of all parties. And so looking at March dates, I have March 13th. It's rare, available all day. And I want to preface this by saying, just to give you an idea, when I am setting a hearing for an hour or more, I am looking into June just because of the court's calendar. And so this is a rare opportunity to have this to address the motions to classify and potentially closure. What does that look like for the parties?
on the 13th.
Thank you.
Your Honor, I think, this is Richard Novak, I think, and I would defer to Mr. Judd, but I think one of the attorneys of record for the media entities had a problem with March 13th when the clerk initially floated that date, but I may be wrong about that, and then I can address the defense's availability on that date.
Well, I wish to address defense's availability first.
Okay, so I thought that I needed to be on the East Coast for a personal matter. I could probably work around that. The only other conflict we had was that Ms. Visser was scheduled to start a serious felony matter the following Monday morning, the 16th. But we hear what the court's saying. So I can adjust my personal travel schedule to accommodate the court. And I appreciate that the court wants to take advantage of this rare vacancy in its schedule.
Right. Thank you, Mr. Novak. I appreciate that. Mr. Judd.
Your Honor, does the court have a view right now as to whether this would be an in-person hearing or something that could be argued by WebEx?
I will accommodate the parties, and of course, turning to defense, and their preference is important, whether they request in person or via WebEx, or maybe it's mixed. Maybe some of us appear via WebEx. Well, not the court, but the rest of us. So I am open to try to find a solution.
I'm curious about that, Your Honor, but it's not outcome determinative. We will make it work. We realize we're guests in the court, that these issues are important. We recognize the interests that are in play. I'm scheduled to be elsewhere in Chicago that day. I'll appear by WebEx if that's what the court allows. If not, then I'll move those plans. This is a priority, and if that's the time that it works, then we'll make it work.
All right. So the parties, first, is it the intent to be in person? And if so, what are the thoughts about Mr. Judd appearing via WebEx?
Your Honor, the state is open to any procedure that will allow us to have this hearing on March 13th. We can be in person or via WebEx, and we have no objection to other entities, representatives appearing in whichever way is most accommodating for them.
All right. Thank you, Mr. Ballard. Mr. Novak.
All I would say is that if the court is going to open up a WebEx for some participants, we will be there either in person or by WebEx or both, because there are, as Your Honor knows, a few of us. Ms. Nestor will not be present because she's already engaged in trial in another county. But we will, I guess what I would say today is that we will be appearing in person, present in court with Mr. Robinson with us. If there is some reason why one of us needs to appear remotely, then we'll address that with the court.
All right. Thank you, Mr. Novak. So it sounds like we're going to go ahead and set this in person. I realize that, there are complications, and Mr. Judd, it looks like there is no opposition to you appearing via WebEx. And of course, as mentioned by defense, there are certain attorneys that may need to appear by WebEx. So we will accommodate that, and we'll anticipate Mr. Robinson's appearance in person on March 13th. Counsel, given the direction of the court dealing with closure and classification of motions, how much time will you need to conduct your business in court? I want to open that up and lock it down before that date gets cannibalized by other important hearings as well.
Your Honor, this is Mr. Ballard. I guess I would defer to the defense. It's their motions to close and to classify. But I think having a time limit regardless would be helpful.
I'm going to suggest that, Your Honor, that it's going to be more than 1 hour and maybe less than 2 hours. And the reason why I say that is there are multiple motions to classify around the same issues, which are the motion, the reply, and the evidentiary hearing itself. And the court's going to obviously hear not only from the moving parties, which is Mr. Robinson, but the state and counsel for the media. And it would be hard for me to imagine that many attorneys in the court could do all that in less than 1 hour.
Are you commenting on the amount of time attorneys talk?
Only myself. I'm only referring to myself, Your Honor.
No worries. I include myself in that comment. All right. So let's go ahead and set aside 3 hours just to be safe. I don't want any party to feel pressured, but as mentioned by Mr. Ballard, I believe that setting a timeline is appropriate. So let's go ahead and start. How does 10 a.m. on March 13th look? 10, 11, 12, concluding at the 1 o'clock hour.
That's fine for the defense, Your Honor. That might actually allow me to get to my originally planned destination the same evening.
All
so
right.
that's fine.
To Mr. Ballard?
10 a.m. is perfect, Your Honor. Thank you.
All right. And Mr. Judge?
Yes, Your Honor.
All right. Let's turn to the second issue where we have that, I believe it was April 17th date. Does that allow sufficient time to address the evidentiary hearing being requested?
In terms of preparation for April 17th, yes, if that's when the court wants to do it, we will be ready to go on that date. That is, if that's what the court means by sufficient time, yes.
All right. And how much time, Mr. Novak, do you anticipate needing? I certainly want to make sure that all parties have enough time to present what they need to present.
Your Honor, I'm going to defer to Mr. Burt on that if Mr. Burt is able to do so. Looks like technologically he is.
Good morning, Your Honor.
Good morning, Mr. Burt.
Judge, I think on that, because it is going to involve the presentation of extensive exhibits and also some expert evidence, that we'd be looking at a full day, accounting for cross-examination by all the lawyers involved here.
All right. And to the state, what's your input?
A is more than enough to be able to address those issues.
All right. And to the state. I'm sorry, I just, to any other party.
I will defer to parties, Your Honor, on this. As the court knows, we haven't seen the motion itself or the reply. We've seen the state's opposition. But I think whatever the defense believes is necessary, given that they are the party bringing the evidence and the expert, if they believe that a day is sufficient, we see no reason to push back on that.
All right. All right. I do note that we have other issues on that day. I think we're just going to have to bump them. And so we'll go ahead and set aside the full day on April 17th. We'll start at 10 a.m. and conclude promptly at 5 p.m. if needs be. But it is the intent that we fully address the issues and it's not carried over or continued to another day. The court anticipates, given what's presented, has been the practice of the court, that it would take it under advisement and schedule a WebEx hearing to issue its decision. All right, so April 17th, starting at 10 a.m. I'm assuming in person, and Mr. Novak, I don't want to assume anything. In person with Mr. Robinson in court?
Yes, Your Honor, exactly.
All right. All right, thank you, counsel. I really appreciate your working together, and I know it's complicated. You all have busy schedules. Is there anything else that the court needs to address at this time?
Thank you.
Nothing on behalf of Mr. Robinson at this time. Thank you.
Nor from the media, Your Honor.
All parties, I appreciate your hard work and your efforts, and we will be in adjournment until March 13th. Thank you. Court is now in recess.